2015 Retirement Plan Regulatory Update. I will start by giving you my bio. I am the Chief Compliance Officer and Director of Technical Services for Multnomah Group. Excuse me. I assist the firm with the development and oversight of the Regulatory Compliance Program. Prior to joining Multnomah Group, I was in private practice and with a firm that provided regulatory compliance, both at the firm level and to plan sponsors regarding both SEC, state registered advisors, and ERISA and Department of Labor and tax regulations. And I earned my degree from Lewis and Clark in Portland, Oregon. I do want to start on a couple housekeeping items to mention. Your lines are muted to improve the sound quality. If you do have a question, you can type it into the questions box on your panel. The session is being recorded, and slides in the recording will be emailed out to you by the end of the week. So with that, let's get started. Today's agenda, we're going to focus on one major case law update, some current regulatory matters, things that are kind of on the horizon, and then just some miscellaneous topics of interest. So we will get started. The first thing I wanted to discuss was the case law update, Tibble versus Edison. It's a Supreme Court case. Actually made it all the way up to the United States Supreme Court. Excuse me. And that basically, the short version is something that we're not very surprised at all about, that yes, ERISA plan sponsors do have a duty to continuously monitor and remove investments that are imprudent. This case was interesting from the perspective is that it was a statutory of limitations case, meaning that the violations that were alleged by the participants in the plan, there was a question of whether or not they could make those allegations or if they were time barred due to a statute of limitations. And so the question came down to when does the duty to monitor investments, or when does your fiduciary duty start? Does it start when the first investment is added to the plan platform, or is it continuous in that you can't just put a investment in the plan even if it is prudent, but then you can't just ignore it going on over time? And that was the issue here, is the allegation that the investment that was put in the plan, while it may have been prudent at one time, it stopped being a prudent investment due to the performance and or the fees or what have you. So the question is does the clock start running at the time the funds were originally selected, or is a passive retention, meaning not doing anything, an action or omission that triggered the limitations period? Not surprisingly, the Supreme Court found that the trustee has a continuing duty, separate from prudence when initially selecting the investments. They have to continue to monitor and remove those investments if they are imprudent. This case actually clarified the timing of when a claim can be brought, meaning that, if the investment was put in the plan in the year 2000 and left in there until today, the plan sponsor doesn't get out from under, by saying, well, we put this in 15 years ago, so therefore you're time barred. The court clearly said that no, if it becomes imprudent in 2009, you don't just get to leave it in there, and so in 2009 you can still go back and fall within the statute of limitations period. The question didn't answer what constitutes a diligent review. That's really not what the Supreme Court does. They don't make law. Basically, they had to send that question back down to the trial court level to say, okay, now that you have to monitor these investments on an ongoing basis, that's where you have to go back now and say, well, were they monitored? Was the process diligent? That question wasn't answered. The thought is that it likely won't be answered by a court procedure. That issue is more than likely to settle. So plan sponsors still have a responsibility to have a diligent process. Whatever that process is, you have to determine whether or not that's enough. And so, monitoring your investments on a quarterly basis, documenting decisions that you make in terms of the investments, especially documenting the procedures you go through, should be very helpful in backing up that your process is diligent. So the next issue that we're going to talk about is some current regulatory issues, things that are currently going on. If you were on this webinar last year, we talked about the restatement period for qualified defined contribution plans, the 401A and 401K type plans. This is not for 403B plans. We'll actually touch on that in just a few moments after this slide. But in short, you either should have already, if you're on a volume submitter or a prototype plan, you should have already restated your plan document, or you should be in the process of doing that. The restatement period opened in May of 2014. It ends April 30th of 2016, meaning your plan document, if it's a volume submitter or a prototype, it needs to be, it does need to be restated to conform to the standards. The purpose of restatement is all of those interim amendments that you do, HART, PPA, RERA, those interim amendments that you make are all incorporated into the new plan document with the restatement. So the restated plans, the IRS approved the language back in 2014, and they said, okay, we're opening the window of May 1st, 2014. Something for plan sponsors to think about is if you have a newly created plan prior to May 1st of 2014, even though it's only been a year since having that plan, you would still have to restate your plan because the language was not approved by the IRS for use prior to that. So if you restated your plan, or if you started a new plan prior to that date, or even if you started it around that date, you would want to talk with your plan sponsor to determine whether or not you're on the right plan document. Failure to restate your plan can result in some things that are not good. Plan disqualification, which leads to unintended tax consequences. You don't want that to happen, so just make sure that the document that you're using is the document that falls under this restatement period. If plan sponsors are still in the process of restating their plan, it's a good time to take a look at your plan document and decide if there's any discretionary amendments that you want to make. I've worked with clients that have decided, well, we have this hours requirement, we don't want to have that anymore. It's a good time to make that change when you're restating the plan document so that you don't have to restate the document and then go and make another amendment. If you wanted to adopt automatic enrollment for your new plan document, you could do that during this restatement period. Another regulatory issue or issue, for lack of a better term, I guess, is the EPCRS program, and that's the Internal Revenue Services Employee Plans Compliance Resolution System. Basically, this is the correction program that the IRS has if a plan sponsor messes up. It's often likely that no sponsor administers their plan perfectly. Often, operational or other mistakes are made, and the IRS is hoping that plan sponsors will be encouraged to actually go through the correction program rather than kind of fixing it on a go-forward basis and crossing your fingers that it doesn't get caught in an audit. So what they've done to the EPCRS program is that they've made some modifications that allow for not only flexibility in what you can correct, but making it less expensive to correct. I think they're hoping that the 1-2 punch of that will encourage plan sponsors to actually use the program. I think what they've found is that the scope of what was able to be corrected was too narrow, and it was really expensive, and so plan sponsors were often making the decision to maybe correct things on a go-forward basis, and again, like I said earlier, not hoped that they don't get caught during an audit. But now that the scope has widened on what you can correct, and now that it's less expensive, I think they're hoping that will encourage them to go through the process. You know, some of the modifications are added flexibility to recoup overpayments. There's probably one of the things that we see more often is excess annual additions. There's now an extended period to correct that. Previously, you had to do it within 2.5 months following the prior plan year end, and now you can do it up to 9.5 months following the year end, which is generally October 15th for the calendar year type plan. This allows a little more time for the employer to figure out if a mistake has been made, rather than having to hurry within the 2.5 months to make sure that no mistakes were made. It gives them a little more time, and there's reduced fees when you apply for the correction under the Voluntary compliance program. So these additional correction methods, there's correction methods for the failure to actually implement or provide an opportunity to defer. We see that happen often with automatic enrollment. If there's an automatic enrollment program that also has auto escalation features, or even just traditional salary deferrals. A lot of, if paper forms are being used, for example, it can be easier for a plan sponsor to actually miss starting somebody's deferral. What used to happen is there was a mandatory employer contribution of 50% of the missed deferral, and then plus the employer had to add 100% of any related matching contribution if there was one. So if an employee had wanted to start deferring in January, and say a few months were missed, and they wanted to defer, you know, $100 a month, and then they would have got a $100 match on that, the employer not only has to go back and give them the match, which seems fair, but they also have to give them 50% of the missed deferral. And that kind of resulted in a double dip, if you will, on the part of the employee. Not only did they not have the $100 taken out of their paycheck, they got the extra $50 put in the plan. Now the requirements include you know, timely implementation of the deferral elections after the failure. That can range anywhere from 3 months to the end of 2 plan years following the failure. And notice to the employee within 45 days of the failure and the correction. So if you find it 3 months later, you have to give them notice within 45 days, and, you know, notifying them of the failure and the correction. If the plan offers a match, the employer still needs to make the matching contribution for the missed deferral. However, you don't have to, the plan sponsor doesn't have to give the 50% contribution for the missed deferral. Now, this is a very general overview that the time frames, whether it's 3 months to 2 years, that might be different. So for example, if you miss the initial window and correct by the end of the 2nd year following the failure, you still have to do the match if that's applicable, 100% of the match, but your employer contribution, it's, instead of 50%, it's now down to 25%. So depending on the time period of when those corrections are discovered and made, it goes from you either have to pay 0 of the missed deferral to up to 25%, instead of paying 50% from the onset. So again, these options give you kind of more time to detect and correct the missing deferral, but it also provides the reduction in a employer contribution to make up for the money actually paid for the employees and not deferred. So there's less of a double dip there. They allow for more flexibility in the corrections. I think the thing to take away from this is self-correction. In order to be eligible for self-correction, you still have to have proper policies and procedures in place. And documented policies and procedures help you limit exposure to errors, and also help substantiate that you're allowed to correct under the self-correction program and EPCRS. So on the horizon, these are things that are not, you know, current regulatory issues for plan sponsors, but they're things that are potentially coming up. If you are a 403B plan sponsor, if you're in higher education or 403B plans, have never before been on a prototype or volume submitter plan document. There's never been a they've been on those type of documents, but there's never been a pre-approved plan document through the IRS. They are working towards that. They're plan document vendors, such as your Fidelities or your TIACREF, what have you. They have submitted their proposed plan documents to the IRS for review. Plan documents, the window for vendors to submit those documents closed April 30th of this year. And when I say closed, that was the initial deadline for vendors to get their documents in. Potentially, a vendor could still submit a plan document for approval. However, since it's missed that April 30th window, any of those plan documents to be given their letters are going to be delayed. So there's prototype plans where you have your basic plan document through the vendor and an adoption agreement. And then there's volume submitter plans where it's a specimen plan, which is more like a model plan document as opposed to an actual plan, and then an adoption agreement if applicable. Sometimes there's just a specimen plan. So regarding the pre-approved plan program, the IRS will not be issuing, or at least according to what they're saying right now, the IRS will not be issuing determination letters for individually designed 403B plans. So many plan sponsors in the 403B world, we also see them on individually designed plans that have been drafted perhaps by an attorney. What that means is when this pre-approved plan goes into place, which is likely probably about 2017, somewhere in there is what they're estimating. If you choose to remain on an individually designed plan, you can do that. However, those individually designed plans are not going to be given determination letters by the IRS like the current 401k plans or defined contribution plans. Sorry for that. I had somebody in here to change my screen. So the individually designed plans that the 403B providers are on now, you can remain on those. You'll have the choice to remain on those. However, you won't get the assurance like you would under pre-approved program, a pre-approved plan, that the provisions in the individually designed plan are blessed by the IRS, if you will. So again, the IRS is going to be likely to take about 2 years to approve the current plan documents that have been submitted by the vendors. And then after that, they will establish a restatement deadline, which is likely going to be somewhere between 2017 and ending in 2019. That's the best estimate that we have currently. Employers should not, similar to the defined contribution pre-approved plans, they're likely not going to, employers won't have to adopt the pre-approved plans until at least a year after the IRS has ruled on the plan document language. And the expectation is similar to the pre-approved plan program for the 401A and 401K plans, in that it's likely that they'll need to be restated every 6 years to reflect any changes in law, any interim amendments, etc. Let's see. So moving on, similar to the IRS's, this is what's on the horizon, the Department of Labor's Voluntary Fiduciary Correction Program. Similar to the IRS's EPCRS program, the Department of Labor has a fiduciary correction program. There's not a whole lot to say about this. Basically, the spring of this year, the DOL's Unified Agenda and Regulatory Plan, they kind of list the things that they're looking at. The EBSA, they noted an intention to amend and restate the the VFCP program. It was originally adopted in 2002, revised in 2006, and this program, again, very similar to the EPCRS program in the sense that it's designed to encourage employers to voluntarily correct fiduciary violations, and helps to avoid potential litigation if they take steps to correct the violations in a manner that's consistent with the VFCP program. Similar to what the IRS did, the amendments to the VFCP program are likely going to expand the scope of what's eligible for correction and kind of streamline the correction procedures. And the EBSA, the Employee Benefits Security Administration, which is the division under the Department of Labor, they're looking to they'll probably be requesting public comments prior to implementing the new program. Also on the horizon, the much talked about and debated Department of Labor's Fiduciary Rule. So this is a rule that the Department of Labor came out with that has been very hotly debated between, especially I think people more on the broker-dealer side of things. People are very concerned that it's going to limit the availability to give advice to participants in a plan because they're expanding. The thought is that they're going to significantly expand the definition of a fiduciary. So the proposed rule was published back in April 2015. It proposed prohibited transaction exemptions, additional ones, and changes to existing prohibited transaction exemptions. It really expanded the scope of what would constitute advice under the Department of Labor's regulations. Additionally, there's some debate on this rule and the Securities and Exchange Commission's rule for investment advisors on what they define as a fiduciary. But like I said, it's been very hotly debated. The Department of Labor has received over 2,800 letters since proposing this rule. They closed comments on September 24th, just last week. They've met with over 90 industry and consumer groups, and they held 4 days of public hearings. The Deputy Assistant Secretary of Labor recently stated that you're likely to see that feedback is going to be reflected in the final rule. So they've received a ton of feedback. Much of that is going to be reviewed, and like he says, in the final rule there could be some changes that take into account all of the comments that they considered, and the Department of Labor is taking it, quote, very seriously. He did not speculate on when a final rule would be released. However, many anticipate it coming out next spring. I think many people anticipate this date because for political reasons, the Obama administration has made it very clear that they want this rule to come out. It's to help assist the middle class, and so I think they're hoping to get the rule out before the Obama administration departs, and people aren't sure what's going to happen in the scope of politics, in the scope of the next election. So miscellaneous things of interest. They're neither regulatory or case law related. Here are some recent IRS guidance. This has been very concerning, I think, to a lot of our clients in terms of documentation that's required for loans, certain loans and hardships. It's also very contested through some vendors that provide administrations for plan loans and hardships. They provide the administration for plan sponsors. So earlier this year, there was an IRS newsletter back in April that noted deficiencies that the auditors were finding relating to hardship withdrawals and plan loans. It's one opinion that, given the prevalence of plan hardships and loans, the IRS is taking a much more significant interest in this. Part of the argument is, the IRS, if there's a hardship taken, they get their, 10% taxes. Why do they care? I think the flip side of that argument is, for people that where, Social Security is a funding issue right now, the IRS, even if they get their taxes from the hardships, they also are foreseeing an issue with people not having enough money to retire on. So, they've been auditing loans and hardships, and I think what they've been seeing is that self-certification has become the hot topic. A lot of vendors allow participants to basically self-certify that they have a hardship, and then they self-certify that the only way to alleviate that hardship is by taking a hardship withdrawal. So there's a two-step process when taking a hardship. You actually have to have a hardship, and then you also have to determine that the only way to fix that hardship is by taking a loan. So the IRS has basically said, self-certification that the only way to alleviate the hardship, we're okay with that, but we're not okay with participants just going online saying, yes, I need a loan. Well, my plan doesn't, or I need a distribution, and my plan, the only way I can get it is if it's a hardship, so I'm just going to say I have a hardship. Basically, they found that participants often, I hate to use the word lie, but lie, in that they need a hardship, and so they go on, they self-certify, and the money's provided. The IRS has kind of caught on that participants have figured out this way to get a distribution to which they would not otherwise be entitled to, and so they have said that self-certification is not enough, that plan sponsors, you are required under the hardship regulations. Well, actually, let me take a step back. Not under the regulations, but they have said, plan sponsors, a hardship is specifically defined under the regulations. It's your job to determine that the distribution meets those requirements. Again, there's some vendors that have had issue with this, basically saying, hey, you've never said this before. A lot of the again, non-binding guidance that's been put out before has said that, verification or a statement is fine. The IRS is basically saying now, again, through non-binding comments, that, well, you know what, this is what we're going to look for on audit, so you either need to be able to provide it, or, we're going to ding you in the sense that we're going to note that your procedures are not acceptable. So again, on this, the IRS is saying that self-certification is not adequate in terms of substantiating a hardship. Plan sponsors in the non-binding eyes of the IRS are required to obtain documentation. So if somebody's house is being foreclosed on, you actually, the thought from this is you would actually have to collect, a copy of the foreclosure notice or an eviction notice. If you're using it for medical expenses, you would have to collect documentation on those medical expenses. That issue in particular is very concerning for employers due to rules under HIPAA and privacy issues. The other place this comes into play is on loans, especially if those loans are going to be longer than 5 years. The only reason you can take a loan for longer than 5 years is for a home purchase. So you have to document the home purchase. Going into this newsletter, it got very particular in the sense that they said that a purchase and sale agreement, while it may be adequate to be able to get the loan, that the plan sponsor would, in theory, need to follow up on that to make sure that the home actually closed and that those proceeds were used. As many people are aware, or some people are maybe not aware, after the purchase and sale agreement, a home sale can fall through. So if you take out money from your plan for the home sale and the home actually doesn't close, then really that's not following the requirements of a 30-year loan. So there's a lot of documentation issues that are problematic. Plan sponsors, in order to allow hardships under their plan, it's a burden to collect all of these documents. However, it's in a place right now where if the IRS does come in and audit and you haven't done it, there's going to be issues at least until somebody decides that they want to challenge the IRS on this. And I'm not sure who's going to step up and be the first one to challenge the IRS on their interpretation. But this newsletter gives us some guidance of what the IRS is thinking in terms of what they're going to be looking for when they come in to do an audit. We're hoping that there will be some more clarification given the systems that current vendors have in place for administering loans and hardships. There are vendors out there that allow self-certification, which this throws a big wrench into that procedure. And the thing that plan sponsors that should probably be aware of is if they do have a third party that's administering loans and hardships for them, there's a question of whether or not you can actually allow your provider to keep collecting documentation through self-certification, now that there's a question out there of whether or not self-certification is enough in the eyes of the IRS. At the end of the day, it's the plan sponsor's responsibility to make sure that it's getting done. And so if your vendor is not doing it, there's some decisions to be made there. Is the plan sponsor going to collect the documentation? Is the plan sponsor going to require that any vendor they hire collect the documentation? Are loans and hardships going to be maybe amended out of plan documents because people don't want to have to deal with the burden of collecting loans and hardships? Those are some decisions that a plan sponsor needs to make. One thing that might be a good idea is for plan sponsors to look at their contracts with their vendors to ensure that if that vendor is chosen and delegated the authority to administer loans and hardships, you might want to look and make sure your contract has appropriate language in there that it will be administered in a way that ensures conformance with the regulations or what the IRS has said. Something you want to think about, something you might want to talk with if you have a plan, a counsel. If you have an attorney that assists you with your plan, you may want to discuss this issue with them to see what's in your best interest. I talked about this last year, and I thought, given that we were talking about loans and hardships, it would be good to discuss again. This basically is not it didn't come from the IRS. There was an American Bar Association. It came from the American Bar Association. There are conversations with IRS representatives, which again are not binding, but it gives us an idea of what the IRS is thinking in terms of what they're going to be looking for on audit of plans in auditing of their plans. Excuse me. So one thing that came up was loan defaults and administering loans appropriately. If an employee defaults on their loan, the IRS representative that was working with the American Bar Association, their opinion was that if a loan goes into default, a distribution generally occurs and a 1099 must be issued. If they fail to make it by the due date. And so where that's important is you want to really look at the terms of your plan document to see what your plan document says about loan defaults. Is there a cure period that's provided by the plan? For example, you know, if a loan goes into default, does your plan provide that a participant has 3 months to cure the default, meaning to, you know, get the money back in before it's a deemed distribution? If there's no cure period in the plan document, it's likely a default as soon as they default on a loan, or it's likely a deemed distribution when they default on the loan. And if it's not handled appropriately, that sort of correction has to be done through VCP, the Voluntary Correction Program through the IRS's EPCRS program. There's a lot of acronyms that I'm throwing out there. But the EPCRS program has different levels of correction. There's self-correction, there's voluntary correction, and then there's audit cap. Well, this falls under the voluntary correction method. And loan repayments, another thing that was commented on is the loan is required to be, generally loans are required to be repaid within 5 years unless it's an extended loan period due to a home purchase. And this IRS representative commented that neither the code nor the regulation specifies when the 5-year period begins, and that the regulations state that a loan must be repaid within 5 years from the date of the loan. And so that's something that is potentially a little bit of a hiccup in terms of administration with your record keepers. If it's 5 years from the date the loan is made, so participant gets their money on, you know, January 1st, but record keepers treat the start of the repayment period as the date the first payment is withheld from the borrower's paycheck, there's a time lag there. So that is something that you know, you might again want to look to your record keeper to see how they're administering that. Maybe talk with your plan counsel to determine you know, what, if anything, their opinion is, what needs to be done about a potential discrepancy period like that. Also, per this IRS representative, the date of the loan should be specified in the terms of the plan agreement. The thought was that the start date cannot be after the loan is funded or after the loan proceeds are paid to the participant. And again, that goes to when does the participant get the money versus when does the participant start repaying on the loan. And if it's a 5-year period, this this representative's opinion was the 5-year period starts as soon as they get the money, not 5 years from when they start the repayment. Hopefully that makes sense. But again, if you have concerns about it, the things you might want to do are talk to your record keeper to see how they are handling it, and then talk to your counsel to determine whether or not you need to do anything about it. Again, this is not something that's binding regulation. This is non-binding comments by IRS representatives. Another issue, again, hardships. And this had to do with when a participant takes a hardship, that elective contributions are supposed to be suspended for at least 6 months. That's under the safe harbor. And so the question is how does your plan document read in terms of that 6-month suspension? If it merely states they're suspended for 6 months, does that require the plan sponsor to immediately resume hardships, or excuse me, immediately resume deferrals once that 6-month period has ended? Is there any sort of grace period? Is there anything in the plan document that says deferrals will start back up as soon as the participant wants them started back up? And so it's kind of technical here in the sense that if the plan document simply says deferrals will be suspended for 6 months, the question is, does the plan automatically have to reinstate contribution elections once that 6-month period ends, or is it okay to wait for you know, maybe 3 months after that? You know, what's administratively feasible? What potentially you could experience an operational failure under EPCRS if you wait too long to start those back up. automatically. Is there something that you can put in your plan document that maybe says hardship deferrals will be suspended until the participant elects to resume deferrals? That's just something, again, that you might want to look at your plan document, see what the language says, see how whoever's administering that, if it's a third-party record keeper, see how they're doing that, and again, potentially speaking with your plan counsel on whether or not you need to kind of make changes to your operations, what their thought is on this, again, non-binding interpretation. We are actually a little bit ahead of schedule. If anybody has any questions, I'm looking to see if I have any questions. Feel free to take a minute if you want to post anything through this webinar for questions. Otherwise, if you, if Multnomah Group can help you any way, if you have any questions or want any clarification, you're more than welcome to contact me or your Multnomah Group representative if you want some clarification on this. Otherwise, the slides will be going out probably within the next few days, and I hope everybody got something out of this that was helpful. All right, I'm going to go ahead and shut down the webinar. Thank you for joining, and again, contact us or your, if you have a Multnomah Group representative, feel free to contact your